And joining us once again for another Ag in the Courtroom segment is Dr. Roger McEowen from the Washburn School of Law. Good morning, Roger.
Good morning, Ken. How are you today?
Good. It's hard to believe we're already past the halfway point of 2021. Still
Right.
doesn't mean that things have backed off when it comes to agriculture and the court system. And a
Right.
couple of topics I think are very interesting. I want to talk about. One is the American Rescue Plan, and you have some thoughts and really digging into that. It looks like that we may have a case of the haves and the have-nots.
Yeah, the courts have had some thoughts on this recently. There are two programs in ARPA, the American Rescue Plan Act, that the courts have looked at recently, and they have put both of these on hold as constitutionally defective, as being racially discriminatory. One of those is the Restaurant Revitalization Fund, and that fund was set up such that only during the first 21 days of disbursement of fund monies, grant monies from the fund, socially disadvantaged restaurants could have funds distributed to them. Everybody could apply, but funds would only be distributed to those that were majority minority owned. Well, we had a restaurant owned 50% by a husband and wife. Husband and wife owned 100%. Husband was white and his wife was Hispanic. She didn't own more than 50%. They were deemed ineligible during that distribution period, that early 21-day period. And so they challenged this as saying, well, the way you have defined socially disadvantaged for purposes of getting priority is racially discriminatory. And the court said, you're right. And the Sixth Circuit, United States Court of Appeals for the Sixth Circuit, said it's unconstitutional, as racially discriminatory, and so it is on hold as it pending further appeals, basically, is well put it. The other one is the USDA loan forgiveness program, which is in another section of ARPA, and of course that's important to agriculture. And one of the classifications in terms of the way they dispersed funds in that, they said it had to be women-operated farms and veterans-operated, and then those operated by socially disadvantaged farmers. Well, the way that the rules define socially disadvantaged farmers was done on a racial basis, and it excluded all white farmers. You couldn't be socially disadvantaged if you were white. And the federal district court in that one said that's race-based, and they entered a universal restraining order stopping USDA from dispersing funds while that goes through the court system. So, the lesson on these, the big takeaway is you can't discriminate based on race. And even in the USDA case, or excuse me, in the restaurant case, they said you can't discriminate based on gender. And so to give women a preference, you can't do that either. So just, Lady Justice is supposed to have a blindfold on, and the government, when they disperse funds like this, is supposed to have a blindfold on, and they didn't do it in these situations, and the court stopped it.
All right, interesting stuff. I know both of those topics have been in the news recently. Dr. Roger McEowen from the Washburn School of Law is joining us. More to talk about, so let's take a quick break. We'll come back and continue our discussion in a moment. And our guest is Dr. Roger McEowen, another Ag in the Courtroom segment of what going on. And next topic, Roger, is it's not necessarily a Kansas focus, but I think it's a focus on agriculture, and that's some more developments in the public trust doctrine. And you and I have talked about that before in Iowa, and that can have implications for production agriculture.
Yeah, and just by way of review, the public trust doctrine is actually pretty old. It goes back to Old England, and it came over in the United States and found its way in the common law in the United States. And the states have, many states have statutory versions of the public trust doctrine that put borders and boundaries upon it. What it is originally was a doctrine, a legal doctrine that was utilized, saying that the seas could not be privately owned in the intertidal waters. So you can't claim that for your own. That's to be used as the public to transport goods across and people across, and commercial fishing in certain areas, that it cannot be privatized. Well, that there is a legal theory out there, and there are theorists that have tried to expand that doctrine. to waters that would go through a farm, to streams that a farmer would irrigate out of, saying we've got to keep a certain amount of water in the stream to protect an endangered species, for example. Can even apply to oil and gas exploration to limit, and basically the expansion of this would say these natural resources are owned by the public, and so we should conserve those. Well, when you expand the doctrine like that, it impacts private activities on land. And of course, that's the big asset for farmers and ranchers. And so farmers and ranchers are right in the crosshair of any expanded doctrine. There's been a battle in Iowa for a good 10 years or so, an attempt by certain groups and certain individuals to expand the public trust theory to apply to certain farming practices that would result, they think, in the reduction of phosphorus and various nitrates, finding its way into a water course that would then flow to Des Moines, the urban area there, and cause more. Their argument is it causes more efforts and more money to be expended to clean up the water so that the urban area in Des Moines can drink it. And so they wanted the public trust doctrine expanded because they thought, well, the legislature is not taking action. We're not getting what we want through the legislature, so we're going to force this through the courts with an expanded doctrine. And that hit the Iowa Supreme Court middle of June. And the Iowa Supreme Court said, no, we do have a version of this in the code in Iowa, and it's very narrow, and we're not going to expand it. It's up to the legislature to make those decisions. They said this is a public policy decision. And simply because your members, they told the plaintiffs, feelings, they might feel better if the river were cleaned up and their drinking water would cost less. That's a policy issue to be decided by elected representatives, not by the court. So the court refused to expand the doctrine. And that's the correct result. That really is a policy decision as to what we're going to do with water quality in the state, for example. The legislature sets the policy, and then you have the Department of Agriculture and various other departments that implement the rules in accordance with that policy. So that was a good lesson that the court towed the line there and didn't cross into the legislative branch of government.
All right, and quickly, some more developments when it comes to the federal land and some taking cases.
Yeah, there was a really important Supreme Court opinion. And of course, in late July or late June, right at the end of their term, the Supreme Court kicks out what many of us view as the most important opinions of the whole term. They just come in rapid fire. And we had a Supreme Court opinion actually involving a law and a regulation that resulted from the efforts of what Cesar Chavez was doing in the late 60s and early 70s in California. And California came up with a law, left it up to the Labor Department to regulate this, to come up with the implementing regulations. And what it did is it gave union organizers the right to come on a farm's premises for up to 3 hours a day, for up to 120 days a year, to organize those farms' workers. And what you had in this situation were a couple of farms, a strawberry farm in North California, another farm in Fresno, and union organizers came on at 5 a.m, had bullhorns and were yelling things and trying to organize the workers, really disrupting what was going on at the farm. And the court said a lot of the workers just got fed up with it, and they went home. Some of them did pay attention to what the union workers were saying, but it was really disruptive to the businesses. And so they sued, saying, look, when you give someone access to our property like that without notice, and they can come on and do whatever they want to do, you've really taken a property right from us. And they said it's an easement that you gave them, and we're not getting any benefit in return. We're not getting any regulatory benefit from this at all. And that was the issue before the Supreme Court. Is that a taking of a private property right requiring compensation? And the court said, yeah, that's unconstitutional. It's a violation of the Fifth Amendment. That is a taking of an easement. And so very, very big case. Of course, it impacts California directly, but anywhere you've got a statute like that, the court is saying if there's no benefit flowing back to the owner, what the government has done is unconstitutionally taken your property. It requires the government to pay for it.
All right, Roger, if folks want to learn more about these topics we've talked about and other things on your blog, how can they access that?
Through the homepage of my website, which is washburnlaw.edu/Walter, WALTR, or just a general internet search for Washburn Walter. And they can find the blog on the homepage. Down the left-hand side is the agricultural law and taxation blog, part of the Law Professor Blog Network. And there's a way to sign up for an email alert when I add a new article to the blog too.
Very good. Dr. Roger McEowen from the Washburn School of Law. He is a tax and ag law specialist there. So stay with us. We'll have more coming up.